October. This was outside of a bar in Bedford Heights, more specifically a bar called Touch of Italy. There had been a fight inside the bar. It was about 2:15 in the morning. Once that spilled out into the parking lot, as we've seen in the past, that ended up with gunshots. Now, the man that's being sentenced today, Chantel Ellis, that man in the orange, 29 years old, he was previously charged with aggravated murder. That has been dismissed because he's taken a plea deal in which he's pleading guilty to improperly handling of a firearm in a motor vehicle, grand theft, tampering with evidence, and having weapons under disability. I expect to learn here if they have dropped the murder charge here. This must be some sort of plea deal. Was he not the trigger man? Was he the getaway driver? We should find out this morning. Let's take you live into court.
That has to relate to the dismissed charges. It is our position, Your Honor, that as it stands, related to the counts that we have pled guilty and now been convicted of, that the victims of those crimes would be the state of Ohio as it pertains to its peace and dignity. And then with the grand theft of the motor vehicle, Avis would be the named victim related to that count. And so our concern is that any type of evidence, whether demonstrative or testimonial related to the dismissed charges, would, I guess, at least be inflammatory towards this sentencing proceeding. We would ask the court to exclude any evidence presented related to those dismissed charges for which Mr. Ellis obviously has not been convicted.
Okay, thank you. The court's reviewed the case law regarding this. I'll make those statements here, and then I'll ask Mr. McNair to respond. So the court has this. Mr. McNair, go ahead.
Oh.
Would you wish to say something?
I do, Judge. It's a little curious to both object to evidence and information about dismissed charges coming in, but then talk about the facts underlying those charges in the sentencing memorandum. And even in the charges that you have in front of you, they pertain exactly to the charges that were dismissed. For example, the tampering with evidence charge. This is not a case where someone is tampering with evidence because they get pulled over by the police and they're trying to conceal something under their driver's seat. This is a case involving evidence tampering in a double homicide. And the facts and circumstances of the case and Mr. Ellis's flight afterwards and his concealment or destruction of evidence afterwards all go to the seriousness of the charges and his lack of acceptance of responsibility and lack of expression of true remorse.
I understand that argument. Let's review the law. Revised Code 2929.12 expressly provides that the trial court shall consider certain seriousness and recidivism factors, and in addition may consider any other factors that are relevant to achieving the purposes and principles of sentencing. State v. Franco's 8th District. Conduct by a defendant that does not result in a conviction, much less a criminal charge, can be considered by the court during sentencing. State v. Steele, 8th District, citing the State v. Clayton, 8th District. However, a caveat is that uncharged conduct cannot be the sole basis for the sentence. State v. Gray, 8th District. The trial court considered evidence in State v. Gray, and the appellate court upheld the trial court sentence there. State v. Gray also cited to State v. Shahan, S-H-A-H-A-N, 4th District. Now, the trial court abuses its discretion when it considers acts that were neither charged nor proven in court after the court conducts its own pre-sentence investigation. In that particular case here, State v. Longo, 4th District, the court had spoken to the victim's wife and determined that the defendant had been acting as part of an organized auto theft ring. This is a 1982 case, 8th District. It's older and a bit of an outlier, but there's a distinction here as to the conducting its own pre-sentence investigation report, in which this court has no desire to do any such thing. There is a distinction between sentencing pleas versus jury trials. The seriousness of the offense will generally be based upon the judge's perception of the real facts of what occurred in the plea bargain defense. We'll simply set a ceiling on what the judge can impose. Ohio courts have ruled it improper to impose a higher sentence because the judge believed the defendant guilty of a charge for which the jury acquitted. In plea bargain situations, the court is not precluded from considering the underlying facts in determining the appropriate sentence. State versus Clayton, 8th District. So the court is aware of the case law and the statutes as well, and is also aware of the fact that the homicide charges here were dismissed. The court's going to be considering the facts of the case, but assures all parties that it is going to be sentencing the defendant on what he has pleaded guilty to, not to other offenses that were dismissed as part of this plea arrangement. So the court will advise the parties that you may speak of the facts of the case, just as Ms. Smith has provided a rendition of the facts in her memorandum of sentencing. Page 2, beginning with factual history, the state will be allowed to as well. I understand there's a video. I'm not sure that I don't believe the court will need to see any videos as it relates to this, because I'm sentencing on improper handling firearms in a motor vehicle, grand theft of a motor vehicle, and tampering with evidence, as well as having a weapon while under disability. So the court will rely on the rendition of the facts, and your sentencing motion, that is the written objection, Ms. Smith, then is, shall we say, partially granted, and under these circumstances, the parties are aware of what it is that they should argue, and the court is certainly aware of what it is that it should consider for sentencing the defendant on these cases.
Your Honor. Thank you so much.
You're very welcome. And Mr. McNair, under those guidelines and guidances, you may provide the court with your full, complete factual rendition if you choose to do so.
Oh, Your Honor, thank you. This incident happened basically in the early morning hours of a Saturday, so basically Friday night going into a Saturday morning. At the Touch of Italy in Bedford Heights, Mr. Ellis was there with two companions. He was there with his co-defendant, Ms. Brooks McKinnon, and also with another unidentified, as yet unidentified individual who was wearing an orange hoodie. Mr. Ellis was driving a Jeep Wrangler that he had rented earlier, I believe that same day, well actually technically the day prior, October 6th. And at some point he had some sort of verbal altercation with individuals in the club. Mr. Ellis and his companion in the orange hoodie were ejected from the club, and as they are leaving the club, they're passing in front of it in this Wrangler that he had rented, and his companion in the orange hoodie is in the back seat and opens the rear passenger side door and is basically jawing at one of the security guards. He is still engaging that security guard in this verbal altercation. Jackie's son, Josh, was there. Jackie and both of his sons were there, Josh and Dominic. They were working basically as DJs as a musical act that night. Neither of his sons had disabling convictions. His one son, Dominic, was armed. Jackie also had his own firearm. They were both firearms that Jackie had purchased lawfully and lawfully possessed. His younger son, Josh, came up at one point and is trying to play the role of peacemaker. He's basically telling Mr. Ellis's companion and the occupants of the Jeep, hey, the club is already closing. It's basically 2 in the morning. Everybody's going home. Let's just squash this and all go home. At some point, Dominic also comes up. Dominic is a little bit older. He's basically backing up his younger brother. And at this point, there are 2 security guards and both Josh and Dominic Cunningham at the rear seat of this Jeep. And Mr. Ellis's companion in the orange hoodie cheap shots Dominic. He reaches out and slaps him in the face, and then he's trying to close the door. And at that point, the Jeep drives off. And we acknowledge that as a legal matter at that point, that altercation was terminated. That is the determination that my office made. And Josh then pursued the Jeep, and according to an eyewitness, is basically calling them out and saying, hey, if you want to fight me, get out of the Jeep and fight me. His older brother Dominic also comes up to the Jeep. Dominic is armed, and it is at that point that Mr. Ellis shoots and fires. Now, we acknowledge that it is actually one of Dominic's bullets that killed Josh. We don't know if Mr. Ellis also shot Josh. There is only one projectile recovered from Josh's body. That is the fatal shot, and we acknowledge that that was fired by the firearm that Dominic had. Afterwards, that Jeep left. It went back to Mr. Ellis's residence. And I tell you all this kind of underlying factual information because it gets to Mr. Ellis's lack of acceptance of responsibility and his lack of expression of genuine remorse. That rear seat occupant of that Jeep has to this day never been identified. That is information that Mr. Ellis could provide that would ease the family's mind, that would obviously give Bedford Heights some useful information to complete this picture. No occupant of that Jeep has ever given a factual account of what happened that night. And Mr. Ellis has, both in jail calls and to others, denied even being there that night. And his denial of his presence at the Touch of Italy in Bedford Heights is preposterous. He is placed there almost every way that an individual can be placed there. The Jeep that he rents is the Jeep that is there. There is an eyewitness on scene who identifies him as being there. His phone location data, both in a recovered phone, the native locations from that phone, and from cell tower records, place him there. There are data sessions that the Jeep engages in with cell towers, and both his phone and that Jeep travel from his residence to the Touch of Italy, and then immediately after the shooting, back to his residence. The firearm that he used has never been recovered. We don't know what he did with it. The Jeep that he rented has never been recovered. We don't know what he did with it. We acknowledge that as a legal matter, our office made a determination about criminal culpability for the assaultive behaviors that night, but it remains a fact that his possession of a weapon under disability, had he not possessed that, the Cunninghams would still be alive today. There is a gaping chasm in this case between his absolutely abhorrent behavior and his moral guilt and the legal guilt in terms of what we can prove beyond a reasonable doubt to 12 jurors. I believe some members of the Cunningham family may wish to address the court if the court will allow it.
Yes. Good morning, sir.
Good morning.
And what is your full name? And if you need to spell the first and last name, please do so for our court.
Mr. Jackie Lamar Cunningham.
Mr. Cunningham, would you wish to speak here to the court?
Yeah.
Just address the judge. Try not to address.
Okay. I'm glad you told me that.
I saw it.
Yeah, you
Yes,
saw
sir.
that.
Go ahead.
This is, nobody wins in this situation. You know, that's bad. You know, I always wanted to shoot a gun, so that's why I did a career in the Navy. 100% disabled vet. Persian Gulf, Desert Storm. And so I saw all that. Okay. My boys were not perfect, but they were good kids. I was a single dad. I raised them from the time they were born. They've been in my household for all their life. They knew nothing but dad. They were my best friends. We all worked together. We all played together. We argued, fought, drank, smoked, whatever. Those were my best friends. They did not deserve any of this. They were raised under their dad like men. These kids these days are so cowardly. They want to shoot. I guess that might have been a fault of mine or whatever, that I raised my kids to do what we did back in the day, fight. But now it's just no respect of sense of life now these days with these kids, cowards. And no, my kids wasn't perfect, but they graduated high school. They didn't have any felonies. They didn't have any misdemeanors. They were college bound. Joshua had just signed up for college. He always wanted to, go to school and pledge Kappa and this and that, college bound. Dominic was a sound engineer. He was college bound. I paid for their colleges. I paid for all of my kids' colleges. All of them. My three. My daughter and my two sons. I paid for their colleges so they can go to 4 years of college at any college they want to. I did that as a single dad. And I don't understand how this law can't see a shooting and the person gets out, see it. With the track record and the history, no accountability. How does that work? How does that work? How does that work? That's what we did when we were shooting overseas. Not in the United States, man. My kids wasn't perfect, but everybody, the city of Cleveland is so upset right now. Dominic, let me tell you one story and I'm gonna stop. Joshua, he was on his way to school, and so it's a T-shirt. It's a T-shirt. You can Google it. It's a T-shirt that floats around. All of Cleveland DJs, popular historic DJs. It's about 100 of us on a T-shirt. Mind you, I was a DJ also for 40 years, and I did my time in the Navy, and I got my bachelor's degree in IT. It's a T-shirt that floats around Cleveland. It's all the DJs on it. Our pictures of all of us. This T-shirt was made about 3 years ago. Guess who the first DJ is on that T-shirt? It's my son. That's my son. He's the very first DJ on the T-shirt. That's how Cleveland saw my kids, man. No, they weren't perfect. No. We want to fight. We want to do all that stuff, man. Judge, I just ask you, if you can give him the max, whatever, fine. If you don't, let him go. I'm done.
I see the little teardrop under your eye, son. I see it. I see the teardrop. I know what that is. I know you, man. I know you. I know you people. I know you. I'm shut up.
Your Honor, my name's Justin School, Justin School. Dominic and Josh were brothers of mine. That's my godfather there. In these past months, we've been dealing with unbelievable pain and sorrow. Nothing I'd wish on anybody including the defendant's family. I wouldn't wish it on anybody. The day that I lost my brothers, my entire life changed. I had to change professions. I'm a barber. I'm a pillar in the community. I know a whole lot of people. Everybody knows me. I can't cut hair anymore. They were my first clients. I lost my passion. I'd been doing this since I was 13, 14 years old. They're my first clients. I can't work anymore. My parents have been helping me out with stuff like that. I've had to take on a new career. I ask that everybody understands the true situation that we have at hand. I understand that in this court right now, there is no way to get justice for their lives, as that loss can never be regained. But I want you to know that we hurt, and as you can see, we just need something. We just need something. We pray that we not only can make it through our lives with this cross to bear, but we also pray that anyone else affected by senseless violence such as this can get through it and get the justice that they deserve. I also pray that the defendant can find peace in himself and come to terms with what he did, because violence should never be met with violence. It should be met with understanding and forgiveness. I want the court to know that we want to do what's right. And we thank you for taking this as seriously as it is.
Thank you very much, sir. Mr. McNair.
Judge, we acknowledge that you cannot sentence based on the assaultive or homicidal counts. We acknowledge that fully. But the underlying conduct here gives context to the seriousness of what Ellis did do. And this case is perhaps the most glaring example I've seen of the intense trauma that the current self-defense law can cause. Because this is a case that was effectively investigated as an identification case. And Mr. Ellis knew as early as October of last year that he was a suspect in this case, that he was a person of interest, that the police were looking for him, and he declined to turn himself in or say anything about that. And I acknowledge I am treading a fine line, because obviously he has a right to not say anything. But when one acts in self-defense, that ought to be a position of righteousness. They are acting from a position of righteousness. And to act in cowardice, to not come forward and say, yes, this is what I did, this is why I did it, is something that causes, obviously, enormous pain for a family that is suffering from a loss, and unnecessarily diverts investigative resources into figuring out who committed these homicides. And then, obviously, once they figure it out, then it becomes a self-defense case. Unless the court has any questions, I'll leave it at that.
Not at this time, but as to a later time if I misunderstand or do not have a full grasp of the facts, I may ask you a factual question. For the record, the court will only consider what the defendant himself has entered a plea of guilty to. That's the court's jurisdiction. The defendant does have a right to remain silent. I'll be asking him at the appropriate time if he wishes to speak to the court. I appreciate your comments, but before I turn it to you, Ms. Smith, again, I understand the court's duties and obligations here pursuant to the law. So thank you very much, Mr. McNair. And Ms. Smith, in mitigation then, if you choose to.
Yes, Your Honor. And I do just want to make just a brief comment in response to what the prosecutor has put before the court. And I understand that he's indicated that there's a fine line that is being tread because my client has a right to remain silent. The court has echoed that same sentiment. But I do think that it's a
I'm not acknowledging or saying the same sentiment. I'm saying the sentiment of what the law is.
Absolutely, Your Honor. It's just as far as the law pertains to him having the right to remain silent, not necessarily endorsing any other comments that were made. But with respect to his right to remain silent, it just seems to me as if the state's argument is that somehow him exercising his right to remain silent somehow negates any possibility of accepting responsibility, and that whatever investigation the state's resources had to lend themselves to unravel what happened here somehow should be credited to Mr. Ellis, and he should be punished for law enforcement doing their investigation. I don't think that's a proper statement. I don't think that Mr. Ellis should have to trade his constitutional rights so that, one, he can make an investigation easier, but two, so that he can be credited as accepting responsibility. Your Honor, in general, this is a horrific situation. I don't know that we agree with the state's rendition of the facts. I think that some of them are maybe not intentional, but I think that some of the statements made were misstatements. But the reality of the situation, Your Honor, is that 2 lives were lost. The tragedy cannot be overstated, and there's no words to express what the family has gone through and what my client has gone through. And we'd be remiss to not acknowledge that, and we would be remiss to not offer, as the defense, our sincerest condolences to the family. We know that nothing will ever change or replace what happened, and everybody from that day that this happened in October of last year going forward, everyone's lives will be changed and have been changed. But Your Honor, my client does accept responsibility, and that's not just evidenced by the fact that he has pleaded guilty to the charges that are before the court for sentencing today. I've had many conversations with my client. He accepts responsibility for what has happened here. He's completely devastated by what happened. This is nothing that anybody ever expected would happen or wanted to happen. And I believe when it comes to self-defense law, Your Honor, at the very least, the state has to have endorsed the idea to an extent, because we ended up with the resolution that we did. And with self-defense law, it puts everybody's life on the same playing field. It does not take into consideration whether there's a criminal history, your financial background, where you live. It doesn't take any of that into consideration. It takes into consideration whether a person was placed in a position where the only thing they could do to preserve their lives or the life of someone else was to use equal or lesser force, but not force greater than necessary to subdue the threat. And I believe that that's what happened here. With all that said, Your Honor, the court is in possession of my sentencing memorandum. As it indicated, I know the court reviewed it. A few things that I do want to highlight for the court. I don't want to go through the entire document. That would take way too much time. But I do want to highlight that Mr. Ellis had an extremely difficult childhood. And as the court read in my memorandum, he pretty much raised himself. And one thing that he benefited from his entire life was that he was a very intelligent individual, very intelligent student. He earned his GED at 16 years old and went on to Tri-C. But for some situations kind of out of his control in his teenage years, he was not able to complete that degree. And his life has not been perfect, Your Honor, but when you look at everything that he's been through, not to necessarily make an excuse, but to provide context, it really makes one wonder if he had had different support, different circumstances growing up, if he would be in a different position today. And I think that, unfortunately, a lot of people in our community do not have the benefit of the support that others do, and unfortunately that has an impact on their lives. Still, Your Honor, he understands going forward that whatever he's been through in his life, he cannot lean on as an excuse for his future conduct. I know that as he moves forward, he has hopes to continue his college education and earn a degree, be an example for his 3 children. As I just indicated, Your Honor, he really did not have parents growing up. He was kicked out of his home at 9 years old and pretty much had to raise himself. And he does not want his 3 children to ever have to wonder whether they have parental support, whether they have someone in their corner, someone who loves them. And he looks forward to being the father and the parent that he did not have growing up. So with that being said, Your Honor, as I indicated, he's taken full responsibility for what's happened here. He's extremely remorseful. I know that his life will never be the same after this situation, the same as everyone else involved here. We would ask the court to take into consider all that's been said, everything in the sentencing memorandum, and find that a period of community control sanctions is appropriate in this matter. Further, Your Honor, he has been in the county jail, I believe since about maybe December 5th or 7th of 2023. If the court would consider at that point he has had no income, I don't believe that he would have any financial means to satisfy any fine in this case. As such, we would ask that any fines be waived. Thank you, Judge.
Thank you very much. Mr. Ellis, this is your sentencing. As such, you have a constitutional right to speak to the court. If you wish to say anything, would you like to say anything, sir?
Yes, Your Honor.
You may.
To the family, or to the family, but I just wanted to express my deepest and most sincere condolences. Tragic events took place. Definitely take full responsibility for my role in the situation that occurred. 2 young black men losing their life. Never easy. Like I said, something like this could happen to a family member or a friend of mine. I don't know how I would have been able to take it. So I definitely feel remorseful for the family and the friends of the victims of this case in this situation. Just want to like I said, once again, send my condolences, sincere apologies for the chain of events that occurred in this situation.
So, sir, you said that you take responsibility, or you wish to take responsibility for your role in what occurred. What was your role?
Your Honor, being involved in the situation, not being able to give them, as Mr. Ben said, full clarity in regards to the situation, basically, Your Honor.
Well, we'll get to that, but what about your role that night? I thought that's what you were saying. Because you were talking about 2 men's deaths and you're taking responsibility for your role in what occurred. What role are you talking about that evening? What was your responsibility? What are you taking accountability for? What do you recognize as to what it is that you did wrong and what you wouldn't do again? If I can be very clear with you and blunt with you, sir. That's what I'm looking for. You say that you're sorry, you're taking responsibility. I don't want to put words into your own mouth. Tell me what your role was that you would have, and what you would have changed.
Well, my role in the incident was...
If I could, Your Honor.
No one said, like, this is the opportunity for him to speak without me or you or anyone else putting words into his mouth.
Oh, Your Honor,
I understand that, Ms. Smith. You may continue, Mr. Ellis. Go ahead.
Yes, Your Honor. I would like to say, like I said, my role in the incident was basically
You've stopped there a number of times with your sons. My role in this incident was basically what?
I don't want my words to get confused.
No. That's why I'm giving you time to formulate them, and I'm attempting to assist you.
Absolutely. I say, Your Honor, and to the family, I accept full responsibility for being there and being involved in the situation. Not being able to fully de-escalate the situation and having to where everybody would just go home to their families and continue with their life around.
What type of weapon did you have that night? What was the fire alarm that you pled guilty to?
Glock, Your Honor.
A Glock?
Yes, Your Honor.
And how long had you had that?
Maybe a few hours, Your Honor.
And where was it?
It was in the vehicle, Your Honor.
And where did you get it from?
Purchased it, Your Honor.
You bought it with cash
Yes, Your Honor.
from somebody on the street?
Yes, Your Honor. I'm not allowed to legally purchase it.
You're not allowed to have one, obviously. You've pled guilty already in the past to having a weapon while under disability. So I knew that you purchased it, but was it on the street or did somebody come to your house?
It was on the street, Your Honor.
On the street? From a certain person that you know?
Not particularly, Your Honor.
And for what reason would you have bought it that very day, just a few hours before this incident, as you say?
It was actually presented to me through a friend of whoever had it for sale. And I happen to have one. Just happened to occur on that day, Your Honor.
Was it presented to you or did you purchase it? I thought you said you purchased it.
I purchased it after it was presented to me.
After what?
It was presented to me as something being on for sale, basically.
Somebody said, do you want to buy this?
Basically, yes, Your Honor.
Okay, and then what did you do with it afterwards?
Concealed it.
Okay. And where did you conceal it? I know you pled to tampering with evidence.
Dan DeRose with 19 News. Interesting line of questioning by the judge here for the defendant. We have to end this stream. If you're watching this on social media and want to continue to watch, go to cleveland19.com, click on the Bedford Heights double murder story. The stream will continue there. Otherwise, on Facebook, we'll end the stream as we have another one to get to at 10:30.
I parked it, Your Honor. I left it.
You parked it?
Yes, Your Honor.
So you parked your vehicle
Yes, Your
with
Honor.
the gun inside of it that very night?
Yes, Your Honor.
And you have no idea, do you know where you parked it?
Yes, Your Honor.
And is it still there?